Hello and welcome to Big Picture. I am Vishal Dahiya. The Supreme Court has ordered a number of safeguards to prevent widespread misuse of dowry prohibition provision under Indian Penal Code Section 498A. On 27th of July, the Apex Court gave a ruling that immediate arrests, which were an integral process followed by the police in dowry harassment cases, will not be a part of the process anymore. The police will have to conduct a preliminary investigation before making any arrests, like in any other cases. The bench of Justice A.K. Goyal and U.U. Lalit said that there has been a growing trend among women involved with marital discord to abuse Section 498A of the Indian Penal Code. It added that while charge sheets were filed in 93.6% of the cases, only 14.4% resulted in convictions. The court also ordered the setting up of a family welfare committee in every district to scrutinize dowry harassment cases before local police can arrest the accused. The committee will submit its report in 1 month to the authorities to which the complaint was referred to. Also, personal appearance of husband's family members should not be insisted upon by the trial courts in dowry harassment cases. So, for a detailed discussion on this, we have with us a distinguished panel of guests today in the studio. Let me introduce you to them. We have with us Mr. Marwah, former Commissioner of Delhi Police. We also have with us Ms. Priya Hingorani, Senior Advocate of the Supreme Court, and Mr. Satya Prakash, the Legal Editor of the Tribune. We also have with us Mr. Ritwik Bisaria, the Vice President of Men Welfare Trust. Welcome to the Rajya Sabha studio, all of you. Let me begin with you, Mr. Marwah, first, since you've been at the helm of affairs at the authority which executes all these orders. One reason which has prominently been cited by the Supreme Court while delivering this particular ruling is that misuse of this particular clause. But there is a counter view as well, that all the laws in the country are susceptible to misuse. It is for the judiciary and for the other authorities to check that misuse. Is this the right way to go ahead and check the misuse?
You know, we have a system, criminal justice system, where an accused is innocent till proven guilty. But unfortunately, there is a tendency in these dowry cases particularly, where the arrest is made at the first instance without any preliminary investigation at all. And as the Supreme Court has rightly pointed out, that in these cases there is a misuse of Section 498A. And the family of the girl, who there may be other reasons for marital discord, use this particular provision to harass the man. And I think they have done a right thing by raising this red line and putting this in the law to see that this misuse doesn't happen.
Okay, let me bring in Ms. Hingorani here. It has been 34 years since this law was enacted. It was done in 1983. You must have been, at the helm of affairs, you must have seen a number of such cases. Now, if you go through the figures, and as the ruling itself states, that the conviction rate is pretty less, only 14.4%. So, is that a proper yardstick to go by and do whatever has been done by the court now to put in more safeguards? So, does this mean that so far these safeguards were missing, and that was the basic reason why this law was being misused?
Well, I'd like to make a couple of comments on this. First of all, what is 498 of the code is basically harassment, cruelty for dowry, right? The biggest problem in our country is dowry. We have the Dowry Prohibition Act. The Dowry Prohibition Act says that whoever gives or takes dowry is an offense in our country. We have rules to that effect, that there should be a list made of the things which are given, and the list must be signed by both sides and witnesses. That is not being implemented in our country because the system is mostly of arranged marriages. Society or the norms do not allow people to go and get the list signed, right? according to me, this judgment on paper sounds very good.
Okay.
But on practical terms, on ground reality, it is not something which is going to help women.
Okay.
And I am not very happy with the judgment, because when you talk of making, as it is, there is a delay in these cases, in genuine cases, there is a misuse in every aspect of law. Yes, there has been a certain misuse in this as well. But what about those genuine cases? In all the genuine cases, as it is, there is a delay. There is harassment. What you said earlier when you started, that if the husband or the families are arrested immediately, it's not so. There has been, the Supreme Court judgment has come which clearly says that you will not arrest at the first instance. They have laid down norms and rules where they say now you have to get the permission from the DCP to, if you want to arrest. Then the judgment of Arunesh Kumar clearly now says in 498 cases that you have to give a 7-day notice. If there is an intention of the police to arrest, you have to give them a notice. So all those safeguards have already been put in place.
Okay.
Right? When we are talking of justice, for when we have problems in India because of dowry, when the marriages take place, there is an exchange of gifts. Now, nobody makes, as I mentioned, nobody makes a list. Now, when the girls go to the houses, either jewelry is taken away. In most often cases, it is taken away and kept by the in-laws. That's when the trouble starts. We have been educating the girls. We have been telling the families, illegal awareness programs, that the girl should keep her jewelry in her own locker. Why can't she?
So in a nutshell, you're saying that this is not going to help the women.
This is not going to help the genuine cases where there has been a harassment, cruelty, they are tortured, they are thrown out of the houses, and I'm not talking of metropolitan cities.
Okay.
I am talking of, let's go down to the ground reality and go down to the far-flung villages, rural areas where this is very prevalent and the girls are really suffering.
Really suffering. Well, let's bring in the other aspect of the story out here. Let's bring in Mr. Ritwik Bisaria, the Vice President of the Men Welfare Trust. Mr. Bisaria, do you agree with what Ms. Hingorani is pointing out here, that it is not going to help the genuine cases of those women who have been victims of the dowry harassment cases? But the other viewpoint is that it's going to check the misuse of this particular law.
See, first and foremost, there has always been a confusion which we see in these discussions is, people confuse the Dowry Prohibition Act with IPC 498A, which is to do with the cruelty aspect of the matrimony. So these are two different laws. What this particular judgment is also talking about is IPC 498A and not Dowry Prohibition Act. So keeping dowry part aside, now coming to this particular judgment is talking about pre-trial harassment which happens to the families who are accused in this particular section.
Okay.
Arunesh Kumar came in. There was a judgment of Sushil Kumar in 2005 which talked about this law to be called as legal terrorism, which is a very heavy word that Supreme Court had given. There have been multiple circulars from Home Ministry asking about don't arrest, do not arrest without any reason. There have been other Supreme Court judgments also, but till date whatever has been happening has been purely around putting a bandage on a particular law which has been grossly misused. Right? It has been really been grossly misused in terms of the arrest of just not men. It is also the arrest of the family members.
But Mr. Bisaria, if you go by the NCRB records, there have been, according to the NCRB, the rate of deaths due to dowry has been almost 1 per day, and that seems to be a very, very big cause of concern.
The male suicides in India is happening suicide happening every 5 minutes. Every 5 minutes, one suicide is happening, and the biggest reason, as per NCRB, is family issues.
Okay.
Right. So, so point is, when we talk about data, firstly, NCRB doesn't collect any data about the male harassment. Is a National Family Health Survey collecting any data about male harassment or domestic violence on men? No. Nobody is taking care of the harassment of men happening, and here when the Supreme Court is probably reiterating what they had already given in Arunesh Kumar, they're just saying it again. We are talking about misuse. Everyone is accepting the misuse. Law Commission said that if the misuse doesn't stop, we will have to amend the law, but nobody is amending the law.
Okay, let me bring in somebody who's been closely watching the development of this law as well as the changes which have been brought into this law. Mr. Satya Prakash, how do you look at this? We've seen both sides of the coin. Mr. Hingorani says that it's not going to help specifically those genuine cases wherein women are the victims of dowry harassment. Whereas Mr. Bisaria is pointing out that, you know, it's definitely was a much awaited and much required change which the Supreme Court has ordered now.
The change was required, but the real problem lies in the way we react to a particular problem.
Okay.
In this case, what happened, as a society, we reacted very aggressively or in a very exaggerated form. All of a sudden, we changed the law to the extent that we changed the basic presumption in law that it is for the prosecution to prove the guilt of the accused.
Guilt of the accused.
In this case, even the Indian Evidence Act 1872, that was changed, and a section 113 capital A was added, which changed the presumption. The general rule of presumption is that it is for the prosecution to prove the guilt of the accused. In this case, it is for the accused to prove that he or she is innocent. I'm using she specifically because in many cases, what is happening is this law was meant to protect women. Women means newly married woman.
Newly married,
but
not the married one.
It was being grossly misused by the by that woman's side, and cases were being filed against unwed sisters of her husband or other family members. And in cases, I have witnessed such cases in Tisjari in Delhi, where somebody from the husband's family was brought in a stretcher from a hospital to appear in a court.
Yeah, even the court
And
said, you know, in its ruling, even the court said that a quarter of the cases have women's mother-in-law and sister-in-law as co-accused.
So the law was required to be somehow, some correctional measures were required to be taken. For obvious reasons, the politicians, that is the legislature, this parliament was not in a position to take any action because then women's rights groups would, you know, create human. They have genuine cases.
Okay.
But in general, this law was being misused, and the problem, real problem, is the way we react to a problem. We react in a very exaggerated form, and once, like it happened in rape law, all of a sudden after December 16, the way we have changed the rape law, I am sure maybe in 1 year, 2 years, or 5 years, or maybe 10 years, the Supreme Court will intervene. You can check this record.
On similar lines, you're saying.
It will intervene, and somehow some safeguards will be provided in that law also. The real problem lies in misuse, not misuse in the form of, you know, filing of false cases. Everybody files in many cases.
Okay.
Most of the provisions are misused. But if you don't have any legal safeguards against the misuse, and somebody levels an allegation, and you are, you know, at the mercy of the prosecution, you don't have anything to you are presumed guilty rather, that change in the presumption, that is very that was very dangerous. That still remains. That still remains. What the Supreme Court has done is they
has put in safeguards.
Certain safeguards pre-trial. Investigation begins the moment case is registered. And entire family is behind the bars. That thing was
That's what you're pointing out.
That's what I'm saying. It's not so anymore.
No.
Okay.
What is this judgment saying now is that you have a committee.
Okay, let him complete
that
first,
was happening, and you are talking about 2014 Supreme Court judgment and a couple of other judgments. Despite that it was happened, what the court has done here is they have devised a mechanism. So in each district, one or more than one family welfare committees would be set up, and it is for the first, the complaint would be referred to the committee either by the magistrates who are handling or by the police, and it will be vetted by the committee, and accordingly it will send a factual report along with its own opinion.
Okay, that's what exactly that safeguard is which I'm coming to.
That will form the basis for the police or the magistrate to take further action.
That's where my main objection is.
Okay, and what is that?
Because this has to be done by a judicious mind, by a judicial officer. It cannot be done by a wife of a officer, a businessman, or a person in the community. Or
so you're saying the family welfare committee, which is being suggested by the Supreme Court to be set up by the legal service?
Yes, is my main objection. They say it can be paralegals, it can be wives of working officers, business people, or anybody from society who's capable of. What is the definition of anybody from society who's capable of adjudicating? That committee will assess whether their case is made out or not. Well, they don't know the law. The case, this cannot, it is not, the process should be before a judicial officer.
Okay.
That's my main objection.
Okay, let me bring in Mr. Marwah here. Mr. Marwah, another point. One is this, and another point is wherein court is saying that you know, the preliminary inquiry will have to be done by the police before arresting anyone. So is that a new thing, or was this in practice earlier also?
No, this has to be seen in the context of Supreme Court's general reservation about misuse of arrest, because police has a tendency to arrest a person, and then it can be a source of extortion of money, and so many other things can happen. So in these dowry cases particularly, where as you have yourself pointed out, there's a bigger chance of misuse. So the Supreme Court has, I believe, rightly laid down the safeguards to see that this is not so blatantly misused.
Okay, let me bring in Mr. Bisaria here. Mr. Bisaria, you seem to be not in agreement on certain parts. But do you believe that these safeguards, if you look them one by one, and specifically the one which Ms. Hingorani was pointing out, that this kind of committee and the constitution of this committee is something which is not going to be competent enough to come to a conclusion whether or not a person can be arrested or cannot be arrested?
See, first and foremost, the guidelines do not talk about that this committee decides whether a person can be arrested or not.
But it sends a report.
It just sends a report.
On the basis of which the decision will be taken.
Which is not mandated in the guidelines. It is not mandatory for the police to even accept that report, to be very honest. So we'll have to see how it really gets implemented rather than what is currently written. But at the same time, in terms of any constitution of any committee which talks about matrimonial disputes, it is very important that the people who understand the matrimonial a segment from both the male side and the female side could be part of it. People who have no idea about it, yes, I agree that people who have no idea about it should not be part of it. But to be very honest, I don't see any difference from what is happening today as well, because even today in courts it is sent to mediation centers. Even CAW are sending few of the cases to mediation centers.
Okay, that's one point. That's one point wherein I'll bring in Ms. Hingorani here. You're pointing out that this is not enough. But one reason which is given is that in cases like this, when the husband or the husband's family, somebody from the family, is arrested at once at the first instance itself.
Again,
there are the chances of reconciliation are almost gone.
Believe me, when the matters come to whether the women's cell or they go to the mediation, except for mediation center, the cases are where there is anyway no chance of reconciliation.
Okay.
That is why the family courts was set up. That is why the Family Court Act was brought in. The parameters and the problem in our country is that when they bring an act, the proper implementation of the thing is not followed to the T. The Family Court Act is a very comprehensive act. Under the Family Court Act, all these issues are to be looked into. What this judgment says is actually what was already envisaged under the Family Court Act. Okay. Protection officers, mediators, counselors, the court before the matter goes into the court, because ultimately what is 498A is a fallout of a matrimonial relationship, is a fallout. The family courts work is a provision where when you go for a petition in the court, whether it is under 125 and for maintenance, for even for divorce, you have to go to a counselor. The counselor will see if there is a possibility of you getting together. If they counsel you as well, if it is not possible, then you go in for proceedings.
Okay. I'll bring in Ritwik a little later. Yes, Mr. Prakash.
498A cases would not necessarily go to mediation, because you file a case before the police, and then police they get into action.
Okay.
That is where the problem lies. It is not about one maintenance. You go to the court. And
as Mr. Marwah was pointing out, that it is prone to misuse by starting from the police official level.
And second, the Supreme Court's direction to set up family welfare committees. This is important. Why? Because after all, it's about a family. It's about matrimonial relationship. Maybe, whatever may be the reason, sometimes there are genuine cases of dowry demand and they must be dealt with strictly.
Okay.
But in many cases, and that was the real concern, because there are law commission reports, there are reports of the Rajya Sabha Committee on Petitions, and there have been various, in fact, Home Ministry certain directions. The law was being misused. What I'm saying is, Supreme Court may not be, all these guidelines may not be completely, effective to deal with the situation. Maybe falling short, or maybe there are some lacunae. But still, some sort of relief to those who were at the receiving end of misuse of this law, that it has ensured.
Okay, Mr. Ritwik, you seem to be, pointing out something to what Ms. Hingorani was saying.
Yeah, see, first and foremost, India is one of those very unique countries where a matrimonial dispute is treated under a criminal law. Globally it is always treated under a civil law, but here we are talking, we are a country where the matrimonial disputes are treated under criminal law, and because of which, all these issues are there. If India has to really stand in the global forum, I think we have to really remove criminology from the matrimony and keep it as a civil law.
But that would also require a lot of social changes as well, because dowry still remains the biggest social evil our country is having.
Again, the Dowry Prohibition Act and dowry and 498A are two different laws. Dowry already has a separate law, separate special act under Dowry Prohibition Act. Let's not confuse 498A with Dowry Prohibition Act.
That is
Okay, let me bring in Mr. Marwah here.
There is no doubt that dowry is a big social evil and it needs to be eradicated, and every measure should be under the law should be taken to prevent it. But here the question is not of dowry prevention, it is using arrest as a source of punishment.
Okay.
You can't punish a person till investigation is complete, and an arrest is not necessary always during investigation because the person is available for it.
But the other viewpoint, Mr. Marwah, is that by bringing in these safeguards, this particular law, which took a lot of efforts to make it that strong and stringent, is being in some way or the other diluted. Is that one of the fears?
No, I don't agree with that at all.
Okay.
I'm sorry, but because it is the police misuse.
Okay.
Because the police, you don't need arrest for custodial investigation. Interrogation is not necessary. If the person is available, you can interrogate him. Why arrest him? But the arrest is made to punish him. And now the arrest provision should not be used to punish. There are general directions of the Supreme Court.
Conviction, there is an arrest.
Recommendations, there have been recommendations that you make 498A bailable offence. Rather, that would have been the other safeguard.
Okay.
If you actually wanted to see that there was some safeguard in this, the option with the court or with the legislature is to make it a bailable offence rather than a non-bailable offence.
Okay.
That would have solved all these problems. But again, I am saying there are no arrests now made just overnight. They don't go to the houses and arrest the man or the family. The police doesn't do it anymore. On the contrary, they take a lot of time to say that we are investigating the matter, the judgment is there, we have to give them 7-day notice. I am dealing with these cases on a daily basis, and let me tell you, the women are really suffering. Those women who are thrown out of the houses because of bringing less dowry or not bringing fulfilling the demands, they are on the streets. So and the system is very slow. They are not getting justice. They don't get maintenance. The police is investigating. Investigation system is completely needs
but arresting husband will not give that home.
Reform.
Arresting husband will not give that home.
Yes, Mr. Ritwik.
I'm saying arresting the husband and the family prior to even conviction will not give that home.
Definitely, these are two sides. So let me bring in Mr. Satya Prakash for a final comment. We're running short of time. Mr. Prakash, the point here is that yes, there are two sides of the coin. But as I was pointing out earlier, are these fears that these safeguards may dilute this act true, or are these safeguards the much required presence which in this particular law finally?
Before the Supreme Court order, in fact, the Supreme Court has quoted from not just its earlier orders, it has quoted from Law Commission of India report 2011, and there is a committee, Rajya Sabha Committee on Petitions report 2011-12. There are two reports. Plus, the Supreme Court appointed one additional Solicitor General and a senior advocate, both as amicus curiae in the case. They have taken the suggestions and recommendations of the Law Commission and the Parliament Committee, also suggestions made by these two senior advocates, and thereafter they have gone into the matter.
Okay.
The Supreme Court is not saying you don't convict. Supreme Court is saying, as Mr. Marwah has pointed out, don't use arrest as a punishment. And the real point is, if you are so serious about it, the police should investigate the matter and secure conviction.
Okay.
As you pointed out, conviction rate is just 14.4. So securing conviction would ensure that there is fear of this particular law, and prospective offenders of this kind of crime are scared of doing such things. But to arrest people, and that too in many cases unwed sisters of husband, they have been arrested, and let's not forget that arrest is a kind of a stigma in our society.
It is.
Once there is arrest, and that too of a unwed girl, it becomes difficult for her to.
So clearly,
Supreme
thrown
Court
out of
has
a
simply-
matrimonial home is not a stigma.
definitely
In
both
a
sides,
divorce. I mean, I'm
definitely
sorry.
we are
These
running
are
short of
one
time,
few-
but
far and
definitely.
few
There are-
cases where you
there are
have a sister,
provisions under
unwed
the
sister who
domestic
Well,
goes
violence
to
Act.
jail.
this definitely,
I'm sorry,
this
I'm
definitely,
sorry, I don't agree with this
this
at all.
definitely is a
Don't
topic
agree with
which can
this.
which can endure a lot more of discussion, but we're running short of
I
time.
know, I just want
It
to
is-
say one thing. One comment I do want to make. I would go to that extent and say, in India, as Ved Marwah says, you've said dowry is a social evil in our country, right?
Yes, it is.
Well, I would say arrest both the parents of the girls and the boy and put them in jail if they give dowry. The thing
Thanks.
is, you
Okay.
talk of gifts. Yes, they have now used very cleverly words gift.
Gift.
Well, if you're really serious about making change and bringing about social change, then you make sure that there is a punishment for the girl's parents as well as for the boy's parents.
Okay, clearly
Give
we
her
are
and take her,
running
and
short
that's
of
part
time
the
out
Dowry
here, but
Prohibition Act.
as we can see, there are both sides of the story. While there are fears that these safeguards could dilute the much required provisions in the law to save or protect the women who were the victims of dowry harassment, there's another view which believes that these safeguards were pretty much necessary to ensure that the law could not be misused. But the fact remains that dowry remains the biggest social evil in our country, and apart from the laws, we might also have to bring in some social change to ensure that we can eradicate this social evil. We'll come back tomorrow again with a different set of guests and a different topic. Till then, keep watching Rajya Sabha Television.